Thank you very much, Tom. Thank you very much to the Center. It's an honor to be here. And I thank the previous two speakers for their excellent presentations. Very good base for what we all have to listen to for the rest of the presentation. I'm just going to get the slides up here. Yeah, thank you. I'm, as Tom said, I'm an international arbitrator. I'm based in Dubai. I've been in the region for over 11 years. I'm also the regional director for the AIPN, the Association of International Petroleum Negotiators, which Tim was past president of. And what I'm going to speak on today is oil and gas construction-related disputes, especially design effects and plant malfunction. And now, as arbitrator, I've sat on about 90 cases in the region, so I can speak to you from what I've observed in dealing with these cases. In the construction sector in the oil and gas industry, we often see EPC-type contracts. As you know, there's no standard format for these. These are often bespoke contracts that are negotiated. And I'll just indicate that there are many, many things you have to negotiate in the course of negotiating an EPC contract. Flow-down clauses, payment provisions, termination and suspension, limitation of liability, disclaimer of consequential damages, warranties, on and on it goes. So I just mention that to indicate that sometimes dispute resolution clauses could be pushed to the back burner, and that's something that we want to emphasize in this conference should not be done. Clearly, dispute resolution clauses are integral and should be looked at very carefully. We always prefer staged or escalated arbitration, or I should say dispute resolution clauses, leading to arbitration as the final stage. And Craig Tevendale, who's the final speaker on this panel, has put together an excellent article in respect of this. I commend it highly. In looking at these types of clauses, one should always match the type of clause to the seat, the specific type of contract, the rules you're going to be under, and the law of the seat, naturally. You look, for example, at the logic contracts, the logic form of contracts, they have an escalated, tiered type of clause. So the other point I want to make about this is that often in EPC contracts, the EPC contractor has to perform the work to the point of handover or to the point of operation before that contractor can go to the final arbitration, the final step of dispute resolution. So in those cases, you need interim dispute resolution mechanisms. And I'll speak about those interim dispute resolutions measures briefly a little bit later. But first, in dealing with the tiered clause that you put in, it's important that these become what's known as a precondition to arbitration in order that they be effective. And as arbitrator, I see many jurisdictional challenges where one party will say that the precondition has not been met. Now, in order for a tiered or a stepped clause to be and to comprise precondition to arbitration, whether it be under civil or common law, there are a few elements that have to be performed. Certainly, you have to see an unequivocal commitment to mediation. You have to ensure that there are reasonable but certain time limits in terms of getting to mediation and using the mediation process. And we do recommend that you use well-known institutions that can appoint the mediators and have mediation rules attached to them. And Tom's organization, the ICDR, has a good set of international mediation rules, as do others. The ICC has, and other institutions have mediation rules that you can use for this purpose. Going back to the interim dispute resolution measures that I mentioned before, common ones that we like to see in dispute resolution clauses in the oil and gas industry are dispute boards and early neutral evaluation. Now, for the interest of time, I'm certainly not going to deal with dispute boards and early neutral evaluation to much detail, but I can certainly recommend the AIPN's Model Dispute Resolution Agreement, which Tim Martin, who spoke first, was instrumental in putting together, and it's an excellent, excellent document, and you can download it or certainly obtain it from me if you need a copy of it. It really sets out clearly all of the aspects of dispute resolution in the oil and gas industry for you, and it has a set of guidance notes as well that are very, very handy. Moving on, you can use something like expert determination. That's good for a technical dispute, pricing, or highly technical disputes. The other thing I'd like to mention is that there's nothing wrong with using a court in aid of arbitration, and certainly the rules, most rules, allow for this. For example, the ICC rules say that the application of a party to a judicial authority for such measures or for the implementation of any such measures ordered by an arbitral tribunal shall not be deemed to be an infringement or a waiver of the arbitration agreement. Depending on the rules and depending on the substantive law, sometimes the use of a court is good because of the enforcement mechanisms of courts and of to assist in the arbitration's interim measures. Similarly, the UNCITRAL rules say a request for interim measures addressed by a party to a judicial authority shall not be deemed incompatible with the agreement to arbitrate or as a waiver of that agreement. In these types of dispute resolution clauses and agreements generally, you have to tailor, or can tailor, and I would recommend tailoring, the dispute production or document production process, the selection of the arbitration panel, process for using experts, and the involvement of internal counsel. Internal counsel can be very useful. External and internal counsel should work together and work together in terms of managing the dispute, document retention policies, understanding and communicating the needs of the client, setting the client's expectations, and managing, of course, the budget, which is very important. Moving on to overall risk management, some of the aspects that have to be managed in terms of disputes are indemnities, risks, and links to insurance. Oftentimes we hear in the oil and gas industry about knock-for-knock indemnities. This is where one agrees to bear one's own risks for one party's own persons or property. There are, of course, limits on liability, and when you're dealing with limits to liability and dealing with indemnities, you have to make sure you tailor-make your indemnities so that they fit in with your insurance clauses and with any statutory law, because if you set about excluding things like gross negligence or willful acts, that could run afoul of your insurance carrier or some statutory provisions. Again, an EPC contractor, it takes the risk for cost of completion, if lump sum typically, time for completion subject to certain extensions, quality of design, and performance guarantees subject to certain exclusions. So there are certain areas that have to be carefully negotiated there. Another important area to consider is that of consequential loss. One has to really carefully define what consequential loss means in your contract when you're measuring that risk. Some standard forms, for example, the logic standard form, defines out some direct loss provisions, and so you have to really just be careful about how you define consequential loss. Another area that we see a lot of is force majeure. The main thing is to have, quite similarly to the escalation clause, you have to have very clear timelines, very clear definitions of what constitutes events of force majeure, when they begin, when they end, what the process is for dealing with them, duties during, etc. Otherwise, they can be quite useless unless they're quite well defined and the steps therein are quite carefully set out. In dealing specifically with plant malfunction issues, we look at performance guarantees. There are three typical categories of performance guarantees: output, efficiency, and reliability. And they depend, of course, on performance testing. Certainly, performance testing provisions are very important, have to be negotiated very carefully, and contracts can be very prescriptive as to the types of testing that needs to be carried out. So these are important provisions. In respect of design issues, things that one has to think about are guarantee periods. Typically a guarantee period, is it going to be from mechanical completion or takeover? Is it exclusive remedy? What about latent defects? The guarantee period is often 12 to 24 months. Is there going to be an extension? These are things that have to be very, very carefully negotiated. And just to wrap up, I know it's quite a quick romp through a very complicated area, but just to wrap up, the key things that you have to keep in mind in your company when you're negotiating these provisions are internal honesty. You have to be honest inside your own organization as to what risk you can bear, how you deal with communications internally, and to ensure as the project progresses that you are honest with each other internally as to any problems that you have or any mistakes that have been made so that they can be corrected or dealt with. You have to keep good records, and you hear this in every speech just about, but it's important to keep good records because at my end, at the arbitration end, if the records aren't good, then the case doesn't really do that well. In dealing with the other party, you have to be strict, firm, and consistent. Consistent with what you say, consistent with what you do. You can be honest, but strict and firm. And make sure that throughout, whether it be claims or communications, your written work match your oral communications, because so often I get in hearings the witnesses saying things that are different from what the paper says, and they have a good, perhaps, excuse or explanation for it, but still, it makes the case rather weak. So, these are some tips, some guidance points. As Tom says, if you have any questions, we'll be very happy to answer them. And we look forward to our very passive discussion period later on. And with that, thank you very much.